Sanskrit.
And
Yes, next.
item number 37, the Abhinav Sunil
My lord,
Khedkar.
this is the order passed by the execution of the order passed by the district magistrate. My lord, in fact, there were two properties, my lord. For one property, my lord, the Tehsildar has already granted the possession, my lord. But in respect of the second property, my lord, they are not granting the possession. The order was passed in the year 2022, my lord.
22.
Two, my lord. Till date, we have not received the possession. For the second property, we have filed this petition, my lord.
Yes, so we'll pass the orders. Yes.
My lord.
Also, to the humble prayer, I have uploaded few documents in the reference, which will kindly be seen.
My lord, may I just complete and then I'll
Yeah, okay.
My lord, what has happened in this matter, what their grievance is that they are submitting that there is some stay, my lord. What has happened, if my lords may kindly see, they have preferred a securitization application in 2023, challenging the SARFAESI action and the DMF, my lord. There was an interim order which was granted by the Debts Recovery Tribunal, my lord, that is Annexure P2, my lord.
Yes.
And relevant paragraph is at page 8, my lord. Now the DRT has directed them to deposit 60 lakh, my lord, in 4 equated installments, my lord. Subject to that, there will be stay on DM order, my lord. They have not deposited, my lord. Pursuant thereof, my lord, they have preferred a miscellaneous petition before this honorable court, my lord, that is Annexure P3, my lord.
Just a moment.
Annexure P3, my lord. Now they have challenged, the borrowers have challenged, my lord, in the miscellaneous petition, the interim order passed by the Debts Recovery Tribunal, that is order dated 10/6/2024. Now, my lord, this miscellaneous petition was withdrawn, my lord, with the undertaking given by the borrower before this honorable court that they will deposit the 60 lakh, my lord, in 2 equated installments, my lord. And, my lord, the time is mentioned in the order, my lord, at page 2. Subject to that, my lord, the order, my lord, of the collector would be stayed, my lord. They have not complied with this undertaking, my lord. Until date, there is no deposit, my lord. After that, what has happened, my lord? They have filed a appeal before the Debts Recovery Appellate Tribunal, my lord. Now, in this, it has, if my lords may kindly see the first, I'll read this relevant. Learned, may I read, my lord?
Yes.
Learned counsel for the appellant submits that the tribunal below has not decided any issue on merits and the interim relief of the appellant has been rejected only on the ground of the non-compliance of order dated 9/12/2024 passed by the Honorable High Court. It is further contended that since no issue has been decided by the tribunal below on the merits, therefore the condition of pre-deposit will not apply in the present case in view of the judgment passed by the Honorable Apex Court in Civil Appeal number 5290 of 2025, Messrs. Sunshine Builders and Developers versus HDFC Bank Limited, decided on 17th of April 2025 and has referred to paragraph 16 of the said judgment. Consequently, my lord, the DRAT, my lord, next paragraph may kindly be seen. Interim matter was remanded back to the DRT, my lord. Be that as it may, let the appellant file an appropriate application before the tribunal below within a week, raising all its grievances, which shall be considered and decided most expeditiously, preferably within 10 days thereafter. Till that time, or the disposal of the said application, whichever is earlier, the status quo qua the property in question shall be maintained by the parties only for 10 days, my lord, whichever is earlier, my lord. The stay was granted by the DRT. Pursuant thereof, they have preferred this application, my lord. Amendment application has been disposed of. As on today, there is no stay, my lord. In fact, my lord, so the interim protection was only for the period of 10 days, my
10
lord.
days.
Yes. As on today, my lord, there is no stay. They have not complied with the order passed with the DRT. They have not complied with the order passed by this honorable court, my lord, where a specific undertaking has been given, my lord. Now, what option, my lord, the security creditor is having else to take the possession of the property when there is a specific order, my lord? And there is, in fact, my lord, there is no justification with regard to that, because if my lord may kindly consider that the order under section 14 was passed in the year 2022. One property, my lord, which is situated in Bhopal, in respect of guarantor, possession of that property was given by the Tehsildar to the petitioner, my lord. But so far as this question is concerned, my lord, this property of the borrower, my lord, without any justification, my lord, only the dates were extended, my lord, and till date we have not received the possession, my lord. And in fact, the securitization application was also filed in the year 2023, my lord. So what the Tehsildar was doing from 2022 to 2023, my lord. There's no justification at all. my
That
lord.
was filed in 2023, the DRP case.
Yes, my lord. But order was passed in
2022.
22, my lord, September.
That's the difference, they all mix up.
Yes.
It's a signs of, at least is a.
In fact, I would just submit before this honorable court, my lord, there is a clear violation of these undertakings which have been given before the different courts and tribunals, my lord.
Yes, madam, what do you have to say?
Lordship, may I kindly see the demand notice which has been issued by the bank. Lordship, I have written the same on the reference, in which it has been stated that Lordship 2 crore 90 lakhs is the outstanding amount.
How much?
2 crore 90 lakhs. Lordship, the principal amount was approximately 67 lakh rupees. Now, Lordship, may I kindly see the auction letter. Lordship, in the auction letter, they have already acquired more than this amount, which is 2 crore 63 lakh rupees. Lordship, the principal amount plus the investors already being acquired by the bank.
How do you say the interest keeps piling up? What are the total dues?
My lord, as per demand notice, my lord, it is around 2 crore 60 lakh, my lord. But all these are things which, my lord, the guarantor has filed the securitization application, which is pending consideration for final hearing, my lord. There is an application which is filed by the borrower also, my lord. So, my lord, all these facts can be adjudicated by the tribunal. My lord, these are all the merits of the case, my lord.
DRAT has also
Why the possession should not be handed over to that, my lord?
Yes.
Also, learned DRAT has also appreciated the fact that the bank is not issued notice under section 13(4). Therefore, the proceedings under section 14 cannot be sustained, and therefore they gave us an opportunity to move an appropriate application before the learned DRAT. Now, Lordships, may kindly see the order which has been passed by the learned
Show
DRAT.
me if there is a stay order by the DRP in your favor, which is still subsisting.
Lordship,
Because here in these matters, we don't entertain long-winded arguments. It's not required. It's a special statute.
Lordships, but the bank, if has already acquired the whole amount as mentioned in the demand notice and even more. Lordships,
We are not going to sit.
has been.
We are not going to sit here and decide what the whole amount is. The bank is here. Bank is here. If we have given the entire amount, they should say that there are no dues now. In another case, the bank came and said, no, that there has been a settlement and everything has been paid by the borrower.
So that is my humble submission that now the learned DRT has to decide whether any dues are left.
Let
Has
them,
to-
madam, your entire relief is before the DRP.
Lordships, but
Yeah.
auction our property.
Let them, so you to get it back, you pursue them later on.
Lordships, but the demand notice specifically states that.
Madam, we can't interfere. The Supreme Court has been harsh on the High Courts earlier also for having unduly interfered in these processes when there's a special statute. And you have a specific remedy under the special statute. So take it there.
Lordships, the matter is now listed for the final hearing. Only
There is nothing like final hearing. On first date itself, we tell the Tehsildar to do what he has been directed to do by the collector. That's it.
possession notice has been received.
No, there is no necessity to give you a possession notice. He is supposed to simply come and take possession and hand it over.
Lordships, but they have already acquired the whole amount and even.
So that we are not going to do it. Madam, you have said that, please don't repeat yourself. That is not available to us. We can't even look into all these matters. We can't look into these matters. It's very clear. In the present case, the order passed by the collector under
Yes.
section 14 of the SRPC Act was on
6/9/2022.
6/9/2022.
22.
Full stop. The Tehsildar Bhopal, is it?
Yes.
Tehsildar Bhopal
Yes.
has till date not executed the order, taken possession from the debtor and handed the same over to the bank, to the financial company, to the financial institution. Full stop. The delay caused by the Tehsildar is unspeakable. Full stop. Full stop. The omission on the spot may give rise to several apprehensions regarding his conduct and his integrity. Full stop. As on date, this court is not speaking about. Full stop. The learned counsel for the respondent has informed the court that the entire amount of the loan along with the interest has been paid back to the financial institution. Full stop. The learned counsel for the petitioner denies the same. Full stop. It is also undisputed that there is a securitization application pending before the DRT filed by the respondent. So all arguments and all reliefs that can be given to the respondent are by the DRT. Full stop. Next paragraph. Under this, therefore, comma, the Tehsildar Baragat,
As well as TD Nagar.
Baragat and TD Nagar are directed to execute the order passed by the collector dated 6/9/2022 under section 14 of the SARFAESI Act within 5 days from the date of this order. Feeling which they shall appear in person before this court to give an explanation as to why they are acting in dereliction of the duty. First stop. List this case 610.
Copy of this order may be given.
Huh? A copy of this order be given to the learned counsel for the state for the SSC action.
I'm highly obliged, Lord.